Questioning.
My lord, may I be permitted to mention for application?
Application?
Application section 5.
Yes, give it.
My lord, this matter has been taken up by Justice Partho Sharathi Chatterjee on 24th December 2025.
Part before his lordship.
No, my lord.
What civil revision or second appeal?
My lord, the matter is ready for hearing.
What is the matter? What is the matter? Second appeal or yes? Heat petition. This bench does not have any determination. Unless the matter is assigned, this bench cannot hear it up.
It is assigned.
Assigned, yes, then it will appear.
My lord, this is for daily.
Anyway, it will appear in the usual course. Next week it will appear.
Grateful, my lord.
My lord, I appear for the petition.
And I am paying for the alleged contempt, my lord. The last occasion we submitted, an appeal was pending. Now that appeal has been disposed of. Subsequently, my lord, steps has been taken to comply my lord's direction, and we have issued them intimation for detailed medical examination. Today is the date for detailed medical examination, my lord.
You are for petitioner. Okay, you are also?
I am for the alleged contempt.
Oh, yes, record and order. Learned advocates for the parties are present. It is submitted that in terms of earlier direction dated 17/7/2026, the contemner respondents have issued letters directing the writ petitioner to appear in the medical examination. In the facts and circumstances, the matter stands adjourned till 21/8/2026 for filing compliance report.
Grateful.
My lord, in item number 4, I beg to appear on behalf of the petitioner. My lord, this contempt has arisen out of your lordship's order, my lord, wherein your lordship
Is
was.
it appearing for the first time?
Is it appearing for the first time, my
So
lord?
let notice be issued.
Very well.
Learned advocate.
Lordship,
I think 310. Okay. Learned advocate for the petitioner is present. This application for contempt is filed against the alleged violation of order dated 3/10/2025,
yes.
passed in WPA 23665 of 2025. Top. Let notice be issued upon the contemner respondents.
Yes.
Within 1 week, an affidavit of service be filed. Let this matter appear on 21/8/2026.
Milord, the only difficulty is that the direction was upon the Pradhan to Milord consider the representation. That's it. Nothing more, nothing less.
Anyway, let's see.
Milord, can it be fixed, Milord, sometime prior to 21? Because Milord, the construction is already in progress. Possibly it will.
No, that's a different issue. You have a separate remedy for that.
Against that only we have approached your lordship on the earlier occasion wherein your
Anyway,
lordship
let us see. Okay, you serve notice. Let us see on the
21st under the same
21st date.
Great, very good.
Very short matter, my lord. They have come before the
Under workman compensation.
No, my lord. It is motor accident claims tribunal matter.
You appear in
I am
the
on behalf of
city
the
civil court, no? Usually.
My lord, my lord. My lord, I am on behalf of the appellant in this matter, my lord. Only 2 points on the basis of the enhancement, my lord. My lord, kindly come to the impugned judgment, my lord. That is page number 34, my lord. Only 2 points on the basis of disability and interest point, my lord.
So ground of challenge is what? Disability.
Only disability. To the extent of that was the disability certificate under Exhibit 9, it was 60% issued by the Government Medical Board, but the court held it towards the 50%, my lord. And it has been later on increased to the 70%. My lord, my submission before your lordship, my lord, kindly be taken into consideration at the
This
time.
is page 61 is the disability certificate.
My lord, 61, this is enhanced disability certificate, my lord.
Enhanced.
Kindly see the date, that is 5th October 2018, my lord. Page 61, my lord. My lord, the original is with me, my lord.
60% disability in which portion of the body?
It has been amputed right leg, my lord.
Right leg amputation.
Right leg amputation, my lord. Kindly come to page 60, my lord.
Yes,
That is the
60%.
disability certificate issued in 2006, my lord, after the accident. And the court, it has been Exhibit 9, my lord.
Yes.
It was 60%, my lord.
Amputation of?
Right leg.
And what was the occupation?
Occupation was business as per my plaint,
Flower
but
seller. Flower seller.
I couldn't adduce any kind of evidence on
Anyway,
respect
what
of
was
my
your evidence?
evidence PW1, my lord.
Regarding computation, regarding notional income, you don't have any
No,
grievance.
my lord, no, my lord.
That is page?
That is page, my lord, as per the judgment, my lord, 32, my lord. 33, my lord, pardon, my lord.
33.
33.
Let us see the evidence of PW1.
My lord. It was page number 15 of the running page of paper book, my lord. My lord, may I read out the entire evidence portion? My lord?
Yes. Page 15.
Page 15 and 16, my lord. I was pedestrian at the time of accident, my lord.
So two grounds that instead of 60%, 50% is taken.
My lord.
And
Later on, it has been increased to the 70%.
okay, now the other ground?
Other ground is the judgment from the, and at the judgment, interest point has given 6% from the date of
6%.
order, my lord, instead
Oh,
of date of
order. Yes, what do you say?
6% I concede, my lord. 6% interest from date of application till date of deposit. And my lord, percentage of disablement is whatever has been granted is okay, because as per Rajkumar Ajay Kumar, my lord knows earning capacity, loss of earning capacity. That is it. 50% is fair enough. And my lord, the page 61, which my learned friend has relied upon, my lord, please come to page 61.
Yes.
And then 62. The certificate is valid till 4/10/2028. I want to draw my lord's attention towards this. So this disability is not permanent. And my lord, another thing I
Earlier it was issued on, this is?
issued on,
My lord,
Uh,
24 to 2006.
my lord,
yes,
Then on, that was reviewable after 10 years.
my lord.
And thereafter on
10 years, 12 years.
5/10/2018.
then again it was given on 5/10/18, and it is valid till 4/10/2028. Another thing, my lord, page 33 of the judgment,
33.
my lord. The victim was 44 years.
Multiplier 15 applied.
15 applied, it will
My
be
lord.
14.
Okay, you have not filed any cross appeal.
my lord. So only interest may be granted.
Total compensation how awarded?
My lord, it was 4 lakhs.
4 lakhs. 6% from the date of application.
As per page number 34 of the impugned judgment.
4 lakh.
4 lakhs. And I have received, my lord, along with the interest from the date of judgment, that is 4 lakhs 5,918. I have received.
4 lakhs.
Yes, take down.
5,900.
Learned advocates for the parties are present. Hard learned advocates. The appellant before this court was a claimant in a case under section 166
My lord.
of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 30th August 2019 passed by Learned Additional District Judge 7th Court Barashat North 24 Parganas in MACC number 182 of 2006. Stop. The case of the claimants before the Learned Trial Court may be summed up thus. On 3/1/2006, the victim Shumanto Bishwas was returning to his home from Jaguli, walking along with pavement of the road, and when he reached near Raghunathpur, at that crucial time, one mini truck bearing number WB37A/0159 had been rushing recklessly, endangering the safety and security of passenger by proceeding from Horinghata to Jaguli. All on a sudden hit hard the victim. Stop. The victim Shumanto Bishwas became unconscious due to tremendous dashing, and he was instantly transferred to JNM Hospital Kollani. Stop. He has his right leg amputated, which caused his total disablement. Pursuant to filing of this case, notice was issued upon the opposite parties. The opposite party vehicle owner did not contest the case. Stop. However, the opposite party insurance company contested the case by filing written statement. Issues were framed and evidence was adduced. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose the claim case by observing and directing as follows. It a quote. Page 34. Hey, page 33 থেকে আর page 34 ঠিক আছে? The claimant, being aggrieved by the quantum of compensation awarded, has come up with the instant appeal. Hard learned advocate for the claimant appellant and learned advocate for the opposite respondent insurance company peruse the evidence adduced and the materials on record. Learned advocate for the appellant submits that although the disability certificate reflected 60% of the disability, which was subsequently enhanced to 70%, but the learned trial judge considered the disability to the extent of 50%. Stop. It is further submitted that the learned trial court, instead of granting interest from the date of filing claim case, has awarded interest from the date of the award. Stop. Mrs. Mukherjee, learned advocate for the respondent insurance company, submits that considering the decision of the Honorable Supreme Court in the case of Rajkumar versus Ajay Kumar, reported in dash, the learned trial judge did not commit any error in considering the disablement of 50%. Stop. upon considering the nature of disability and the fact that the right leg of the claimant was amputated, and considering the nature of business of the claimant, which is selling of flowers, this court is of the view that the percentage of disability as reflected in the disability certificate should be taken into consideration. Stop. As under Section 168 of the Motor Vehicles Act 1988, courts are empowered to grant compensation which is just and reasonable. This court is of the view that instead of going into arithmetical calculation, it would be just and reasonable to enhance the award of compensation to rupees 5 lakh. Thus, the claimant appellant is entitled to rupees 5 lakh compensation from the respondent insurance company. So, hence, this appeal FMA 391 of 2024 stands disposed. Judgment and award dated 30th August 2019 passed in MACC 182 of 2006 stands modified to the extent that the claimant appellant is entitled to rupees 5 lakh compensation from the respondent Reliance or Indus-Ind?
My lord,
National Insurance.
National Insurance Company. In the cost title, it is not reflected. National Insurance Company Limited, along with interest at the rate of 6% per annum from the date of filing claim case till today. Stop. The appellant, the respondent insurance company shall deposit rupees 5 lakh along with interest at the rate of 6% per annum within 8 weeks before the Registrar General High Court, Calcutta, within 8 weeks from the date of communication of this order. Stop. In the event compensation awarded by the learned trial court is already deposited, the balance amount be deposited. Stop. The appellant claimant will be entitled to withdraw the compensation upon compliance of necessary formalities. Okay. The court fees of with regard to the enhanced amount be paid before the learned trial.
Citation is, my lord, 2011, volume 1.
Rajkumar Bhatt says ওটা
Deeply obliged, my lord.
পরে দিচ্ছি, হ্যাঁ করছি। I'm for the appeal.
There is no cross objection.
This is employees compensation appeal, my lord, wherein the employer-employee relationship has not been proved.
Oh. Yes, you are filing the paper books. Abu Saab, copy of the paper book.
একটু কথা বলো। হ্যাঁ, কিভাবে করে নিচ্ছি? আরে,
Yes.
My lord, this workman, he claims to be a Khalashi under the respondent number. Respondent number কত গো?
1 to 3.
দাঁড়াও। Under respondent number 4.
So this is the case of the claimants.
My lord, this is the case of the claimants. Let us come to page 1 of the paper book. The last paragraph, my lord. Page 1.
Yes.
Late Dilip Bagdi, aged 39 years, son of Sri Shadhan Bagdi.
Page 1 or page 2?
1.
Yes, page 1.
Last paragraph.
Yes.
Late Dilip Bagdi, aged about 39 years, son of Sri Shadhan Bagdi, a workman designated as Khalashi or cleaner employed by the above named opposite party number 1, received personal injury by an accident on 2nd February 2022 arising out of and in course of his employment resulting in his death on 2nd February 2022. The cause of injury was the deceased employee, as per the instruction of opposite party number 1, was on duty in his Bolero pickup van bearing number such and at about 2:50 p.m. while as per instruction of the driver of the said vehicle, he was going to purchase the drinking water bottle near the MAMC flyover on NH2 under PS New Township. Suddenly, one unknown four-wheeler going towards Asansol from the side of Burdwan knocked the Khalashi from behind. As a result, he got serious injuries and was shifted to SD Hospital, Durgapur by some local people, but the attending doctor declared him brought dead. This is it, my lord. He was dashed by a unknown vehicle, he is claiming. And that unknown vehicle has not been found, my lord. And this vehicle, which has been the owner is Upendra Shah. He is claiming to be his Khalashi. He did not come before the commissioner with a written statement or any piece of document to say that yes, he was the Khalashi under him. So employer-employee relationship was not proved as is required under the Act.
Yes.
Please come to page 24, my lord. The deposition of the claimant. I am the petitioner of this case. I have filed, my lord, have got it?
Yes.
I have filed my, I am the petitioner of this case. I have filed my affidavit in chief. The same has been drafted and typed as per my instruction by my learned lawyer, and the contents have also been read over and explained to me in Bengali by my learned lawyer. After being satisfied with the contents of the same, I affix my signature in Bengali on the same. Then I have also filed certified copy of FIR and taken such and such, copy of PM report, copy of insurance policy of the pickup van, Aadhaar card of my deceased husband, marked as exhibit 1, 2, 3, 4, and 5. I pay for compensation 14 lakhs 1,750. Now the cross says I did not see the accident. My husband was
Opposite party 1 is the owner of what?
owner
Owner which
employer.
party?
Owner employer.
Okay, he did not appear to contest the case. Okay.
It is very important that he should appear. He should say that, yes, he was my employee.
Okay, he
According
did
to-
not appear, so it is declined.
Declined.
Okay, opposite party number 2.
Opposite party number 2. I did not see the accident. My husband was working as khalashi in the pickup van of the OP number 1. My husband was working for about 20 to 25 years under the OP number 1 prior to his death. FIR was lodged by my husband's younger brother, namely Uttam Bagdi. We have not assigned any reason in the FIR for lodging the same after 1.5 months from the accident. Not a fact that no accident as stated by me occurred involving the said vehicle of the OP number 1. I have not filed either of the seizure list concerning seizure of the pickup van of the OP number 1 or UD case report. I do not have any document regarding employment and income of my deceased husband. Not a fact that my husband was not working as a khalashi in the vehicle of OP number 1. Not a fact that my deceased husband did not die in the said accident while working as khalashi in the said vehicle of the OP number 1. Not a fact that my husband was more than 45 years old. Not a fact that my husband was not an employee of the OP number 1 at the time of accident, or that his monthly wages was less than 10,000. Not a fact that we are not entitled to.
Regarding income, there was no proof.
No proof.
How much did the this witness say regarding income? 10,000.
She did not say.
No, income.
In the claim application, 15,000.
15,000. Okay.
My lord, according to the Employees Compensation Act,
So there is some fixed compensation. I think it is not, does not depend on the income.
yes, for the 50% deduction, yes. According to when the case was filed, I have to see that. Kabe file hoyechilo? Accident kabe? The case number
2022.
22. That is 8,000, 50% half is for 4,000. 8,000 is the slab. 50 the
The
calculation
schedule rate is there.
there.
Schedule rate of compensation.
My lord. But here, employer did not come before the learned commissioner to prove his employment. And my lord, please come to page 25.
Yes.
The deposition of the manager of the insurance company. I am working as legal claims manager of Reliance General Insurance Company Limited and posted at Zonal Office, Kolkata. I have been authorized by our Chief Compliance Officer to depose on behalf of insurance company. This is power of attorney. Today, I have filed in my affidavit in chief. The same has been drafted and typed as per my instruction of our lawyer. I've gone through the contents of the same. After being satisfied with the contents of the same, I affix my signature in English of the same. I have also filed the insurance policy of the pickup van bearing. Let the
So
same.
this claimant was the khalashi of this pickup van.
They are claiming to be
Yes.
that.
So far the name of the owner is concerned, that was verified. So far the registration.
Not this, the accident happened
Yes.
not inside the vehicle, so that he can prove that yes, he was the khalashi.
No,
Number one.
question
Number
is,
two is that
this vehicle is the vehicle offending vehicle.
no,
So he is claiming that he is the khalashi of this particular vehicle.
but he could not prove that.
Oh, now the question is, if he is a khalashi of this vehicle, he has mentioned the owner's name.
Right.
Owner's name. So this vehicle must be in the name of the registered owner.
This vehicle is in the name of the registered owner, but the
Who he claims himself to be the employee of.
yes, of
That is there.
that is there.
And he is a party to this claim case.
Yes, the owner.
Owner of this vehicle.
My lord.
Okay.
And the cross-examination is from the petitioner is the insurance policy is a third-party policy and it only covers third-party insurance in case of accident. So here he is claiming, the claimant is not claiming compensation as a third party. He is claiming compensation as a workman under the employer. The respondent number 4. wherein it has not been proved unquestionably by the claimant that he was the Khalashi under respondent number 4.
So
Which
does the
very
insurance
important.
policy cover Khalachi? Insurance policy?
My lord, every Bolero pickup van it is, so there will be some
No, question is if the insurance policy covers Khalachi, then Khalachis are entitled to get.
Khalashis are entitled to get, yes.
He has to prove himself to be Khalachi.
Yes, my lord. Yes, that has not been proved. It is very, very important in the WC before the commissioner to prove that the employment has to be proved, my lord. If he would have proved the employment, then no appeal would have been there, my lord. And that also the FIR has been lodged so much after the accident. That also nearly 1.5 months later.
FIR ended in charge sheet or this FRT?
Charge sheet was there.
Okay, charge sheet is there.
Charge sheet was, let me,
That's
please.
there.
Charge sheet card against her.
That means something is there.
No, no.
That means something is there.
No. Unknown. So now unknown vehicle dashed him.
No,
That is
charge
also
sheet, the
charge sheet, my
investigation.
lord, page 28.
Page 28.
Page 28. My lord had got it. Brief fact of the case. The fact of the case in brief is that on 12/3/2021, SI Jayanto Dubey of NTSPS received a written complaint from one Uttam Bagdi, son of Sadhan Bagdi in Ganatantra Colony, PS LTS such and such, to the effect that complainant's brother Dilip Bagdi, working as a helper of mini truck, bearing registration number such and such, on 2/2/2022 at about 14:05 hours, the driver of the said vehicle parked his vehicle near DVC More, NH2 flyover MAMC, and said Dilip Bagdi was going to buy water bottle after crossing the NH2 road. That an unknown four-wheeler vehicle dashed his brother Dilip Bagdi from behind after coming from Bardwan side and fled away towards Asansol side. As a result, complainant's brother received injuries on his person and he was shifted to SD Hospital Durgapur for treatment by local people, and he was declared as brought dead. In this regard,
But while admitting this case, any question of law was framed by the division bench? On which point the matter will be heard? It was not framed.
employer-employee relationship.
No. What is the question of law framed by the division bench? Okay, let me see in the paper book. It was, no, because it requires admission, it was admitted.
Yes, right.
Where is the order of admission?
Order of admission of the Ahad. Yes, sir. Could be in the report.
My lord have got the order.
No, it's not in the paper book.
Yes, ma'am. Yes, sir. Does it put over? Is on chat.
আরে বাপরে না, আমাদের অর্ডার করতে হয় না পেপার কিছু না। বলবে ও খালাসি ছিল।
Okay. After the appeal is admitted, it is sent to the single bench. Okay. So unlike second appeals, no substantial question of law is framed.
Employer-employee relationship, the second page, my lord, see, the learned division bench has said that since it is not there, how to, means the deposition is not
This court is inclined to look into the evidence adduced by the claimant and the opposite party number one as regards employer-employee relationship between the victim and the opposite party. Anyway, whether the claimants were able to establish.
Yes, they
That
did
is-
not establish, my lord.
Yes, that is to be seen. Yes. So this the vehicle could not be traced out. So it remained unknown. Yes. Anything else?
And later on, after 1.5 months, they implant the vehicle and say that, yes, my Kalashi,
Where is that implantation order?
no implantation order.
No. Where is the mention of that particular vehicle?
That no, in the brief facts of the in page 28, it is said that he was working in that vehicle in this Bolero pickup van, and he was crossing the road to get a water bottle, and another unknown four-wheeler dashed.
Anyway, so far this person is concerned, he was the as per the claimant's case, he was the employee of Khalashi of this vehicle, but an unknown vehicle dashed.
Yes, that is true. He is claiming to be that, but here the employer did not come before the commissioner to say that, yes, or he did not give any appointment letter or any salary register or any voucher. Nothing has been done to show that, yes, he was working under respondent number 4.
Very well. So that is there, and some other vehicle charge sheet was submitted against some other vehicle subsequently.
No, my lord, could not be because it was untraced.
Yes, so it could not be submitted. Yes, this is your one ground, that employer-employee relationship is not proved.
Right.
Then quantum, anything to say?
Quantum তো দিয়েছে।
Have you challenged the quantum?
Page 16, my lord.
Page 16.
The quantum, my lord, have got it. 1, 2, 3, third page, third paragraph.
Yes.
Monthly wages 8,000 as per
Page 16.
page 16 of the paper book.
Yes.
As per government notification, monthly wages was 8491 at the relevant point of time. Accordingly, compensation.
No. As per government, as per page 16 is something else of the paper. Page 16, third paragraph is as bearing the uncorroborated oral evidence
Yes,
of.
yes. The last part of that paragraph. my lord.
Okay, 8491.
Yes. Thus, in determining compensation in terms of Section 4 of the Act 1923, this court has to take into consideration notified monthly wages of cleaner Khalashi as notified by Government of West Bengal. As per government notification, monthly wages was rupees 8491 at the relevant point of time. Accordingly, compensation would be 50% of this and the relevant factor which comes to this.
So that was there. And so regarding if your ground of challenge is with regard to quantum, what is the ground?
Quantum, I do
You have not challenged.
not challenge.
Only with regard to
To
establishment of this fact. So
establishment of
quantum, you see, with regard to quantum, hardly there is any scope to enhance or reduce. So far, Workmen Compensation Act is
my lord,
concerned.
I'm grateful.
Interest is also awarded.
Interest is 12% as per the act. From the 1 month of date of accident, 1 month from date of accident till date of deposit is 12%.
So that is there in the act.
That is there in the act.
So no question of reducing that also. Yes, what do you say?
Kindly consider, my lord. It has not been proved, they are saying, but it is true, it has not been disproved, my lord, that there is no relation in between the employer and employee. Accident took place, it has been proved. It is the duty on the part of the police or the employer. Employer has not come. That for the said reason, well, claimant cannot be supported. That the incident took place or not. It has been proved, yes, incident took place. An employer has
According to you, accident is proved, death is proved.
that is proved.
So only the employer-employee relationship is not proved, which is vital.
Yes, but it has not been disproved also, my lord. It has not been disproved. By way of some evidence, no, he was not the employee. It is totally false. It is not true. No reflection is there. Then such point as raised by the appellant, whether it will, by considering the same, whether it is maintainable or not. Then appeal is not maintainable. It has been discussed by the learned judge of the court below. Yes, accident took place, employee-employee relation is there. And others point, it has not been challenged. Quantum or any other proceeding. In other,
So quantum, I think there is hardly any scope
Scope.
to reduce or to enhance, not even with regard to interest.
It is their case, my lord, they have to prove the employment.
employee, I am, claimant is saying that I am the employee. But it has not been
He
disproved.
Or
only
Clement's
said-
family, victim's
Family.
family.
Victim family saying just I am the employee.
Then it has not been
And that
disproved.
also while
By
crossing
way
the
of documents, no, he is not the employee under the A, but he was the employee under the B. Then it is true. I am working in another company.
that he was
Then
the
how-
khalashi.
I-
That does not-
now the petition is maintained. But it has not been disproved. The employer does not come before the court below. Then, my lord, whether kindly consider the claimant will suffer or not, it may be considered.
So any other local persons could have proved, any local person that he is the, or any worker from the employer.
My lord, co-employee could have come.
So-
Yes, my lord, I've been practicing
Yes,
in
but-
employees
but-
compensation
but
for
it
last
has not been-
27 years. I know that the employer has to
delay,
come.
one month, 15 days most
No,
probably.
no, leave that.
It is not the, I
There are
think.
many ways to corroborate, bring the persons of the locality or the other staffs. There are many ways. You see, after the person, okay, the employee has passed away, it is the burden upon the victim's family. So if the employer does not come, this local persons or other staffs, they may be brought to corroborate the matters.
Something has to be brought before the commissioner to prove his employment.
Any documents filed with regard to his employment? 7 except oral evidence, nothing was filed.
Yes.
So whether this oral evidence was sufficient for the learned tribunal?
LCR call for.
আরে, উনি অন্য কথা
না
জিজ্ঞেস
না ওইটা
করছেন।
দেখে রেকর্ড হতে পাওয়া যাবে।
No, no, you see, in the paper books, you must have incorporated documents. If any documents was exhibited, definitely you could have,
No, no document.
no,
No document. In the cross-examination also, she has said that no documents she has filed to prove the.
My lord, kindly, then I have to see the LCR. Actually, it has been
Huh?
filed as hurriedly as.
no, whatever it is, whatever is there in the paper book, I shall consider that.
Yes.
The trial court records are there.
Nothing was filed, my lord.
No, in this court, trial court records came.
Yes, আছে
Ache. Anyway, go
দেখি।
through that.
একটু দেখি। তুমি আগে satisfied.
Any documents filed or not. Otherwise, it has to be decided whether this oral evidence is sufficient to come to conclusion.
Documents আছে, exhibits আছে। এই যে FIR উত্তম বাগদি করছে। তারপর চার্জশিট স্যালারি সার্টিফিকেট দিয়েছে এটা কি আরে এটা তো অথরাইজড লেটার নাথিং No, my lord.
So no documents filed. Yes, record. Learned advocates for the parties are present. Heard learned advocates. The hearing is concluded. Let this matter appear for judgment on 6/8/2026.
Yes. I'm grateful, my lord.
Yes, applications.
Number 17.
Yes, application can too.
My lord, I am for the appellant. My lord, judgment has been already been passed. At the time of filing, the appellant number 3, namely
Okay, let me see the application.
Vivechana Singh, daughter of late Vikas Singh, was a minor. However, the appellant number 3 has now attained majority. Therefore, I pray that your lordship may kindly pass appropriate direction regarding
Appellant number 3.
appellant number 3.
This appellant attained majority.
Yes.
When?
My lord, her date of birth is 18 January 2007. Now she is around 19 years old.
Yes, record an order. Learned advocate. Who is appearing? Yes, do you appear for ICICI Lombard? So you appear in this matter? I don't know who is appearing. It's a disposed matter. For application for recording majority. Oh, you are.
I am appearing. He naam ki?
Chandramaya.
Oh, acha.
Even if you are not appearing, if for this purpose you can appear.
Appeared in this case, madam.
Yes, yes. Learned, yes, give her a copy. Yes. Learned advocates for the parties are present. This is an application filed by the appellants to record the majority of appellant number 3, Vivachana Singh. Stop. It is the contention of the appellants that the appellant number 3 attained majority during the pendency of the case. The school final certificate is annexed to the instant application. Stop. Thus, this application stands allowed. Let the majority of appellant number 3 be recorded. Can 2 of 2026 stands disposed. Let the amendment be carried out within 2 weeks. Okay. 18. New India Assurance Company. Okay, not today. Not today.
21.
Yes, next.
An application for condonation of delay. My lord, the copy was served.
23, that is Union of India.
I am for the appellant.
Okay, service is affected.
Yes, my lord. They have appeared and filed written objection against our application.
So it's better to take it in their presence because an opposition is filed, as because they have appeared. Anyway, not today.
24 also, my lord.
Same.
They are not appearing, my lord. Yes.
Not today.
26. 7. 28. 9. 30.
30, what is this application?
My lord, they are.
Oh, in the scene, yes, Mrs. Mukherjee, you are appearing this in the scene general. Yes?
It is Shomallo Ganguly.
Oh, right. So whose application, your or their?
No, their application, my lord.
Not today.
My lord, my submission is that insurance company has they have come in appeal against an ex parte order. They have already filed a miss case under Order 9, Rule 13 of CPC, which is
So that
pending.
can be, so this can be disposed with the liberty to proceed with that.
Yes.
That liberty can be granted. Anyway, in his presence, I shall pass that order.
32 and 33.
আর কি আছে? ঠিক আছে, হিয়ার ডেকে দিন তো। Yes, call the list.
I'm appearing for petitioners, my lord.
Yes, this application stands allowed. Let there be an order in terms of prayer A, B, and C of the notice of motion. So and so are appointed as joint special officers. Learned special officers shall at the outset hold discussions with the parties and try to mediate so that amicable settlement and partition is arrived at between the parties. In the event amicable partition can be arrived at, learned special officers shall record the terms of settlement arrived at between the parties and submit report in court. In the event settlement fails, the special officers shall mention the same in the report and assume jurisdiction of Advocate Commissioner. Thereafter, the learned special officers shall cause inquiry at the suit property, take measurement by appointing surveyor and valuer to partition the property by meets and mounts. Learned special officers shall submit report about the progress after 1 month. Fix 9/9/2026 for report of the special officers.
Great.
Just a minute. It will not be 9. It will be 11/9/2026.
My lord.
is not executable since the plaint is not available, etc., etc. Similar application filed by joint administrators not parties to the suit. Identical reliefs almost claimed. I will take the last three orders. Adjournment sought on their ground because of a few personal and relevant medical reasons. Prior thereto, their case has been before this honorable court that the plaint is not traceable. My lord knows better than all of us at this side of the bar, my lord, in execution proceedings. What is to be looked at for the entire, it is the decree. They are not here
Time
today.
was sought for on behalf of the joint
Yes,
administrator.
my lord. My lord will kindly turn over to the previous order.
26th June, 15th May.
Yes, my lord. Mr. Dev was all along appearing. My lord will kindly turn over to all the last few orders.
Mr. Gupta is
Mr.
representing.
Gupta was leading me. My lord, may I just say this? We did not object to the adjournment sought for because the joint administrator's wife not had passed or when she was unwell. That time has passed more than 2 months now. May I just say this? I don't want to take an order in their absence. That is not right. That is not what we have been taught, and that is not what my lord encourages. Kindly, specially fixes it for one specific day. Lord, we shall come and thrash out the application. If the order of the division bench and the order of the single bench dismissing the old section 47 is shown to my lord, that will be more than sufficient. 75.
The matter has to be disposed.
Yes, my lord. 75 lakhs admitted in my favor. Part decree satisfied by transfer
The
of.
question is, if both are agreed to go for mediation, I can send
The
it
question
to
of
you.
mediation does not. They filed a 47 application, my lord.
Very well, it can be settled at the execution stage also.
My lord, they do not intend to settle.
The Supreme Court is encouraging mediation.
They encouraging, my lord, but kindly, my lord, pardon me for saying this. It will be an exercise in futility. Kindly, my lord, pardon me, my lord.
Yes, record an order.
Kindly fixes it for a specific date.
Learned advocates for the
Decree
holder. Petitioner is present. None appears for the judgment dated.
They are not parties.
Okay, none appears for the applicant in GA2 of 2024. However, in the interest of justice, actually next Friday, this bench may not sit.
I am not seeking for next Friday. Any day subject to my lord's diary permitting, my lord fixes.
This matter, the interest of justice, the matter stands adjourned till 21/8/2026 at 2 p.m.
Lord, may I just request one thing, my lord? My lord has seen the orders. All adjournments could be peremptorily adjourned for their absence, my lord.
Okay. No further adjournment will be granted on the said day.
And my lord will then hear out the application. I shall defend it. The application is on board.
Affidavits are also exchanged in that.
Everything is complete.
In this GA2.
My lord, almost 10 years ago.
So entire thing, that is no, GA2 is filed recently.
Yes, I'm sorry. Almost 10 months ago.
So affidavits are complete in GA2.
Everything is
so entire matter is to be heard out.
In their absence, my lord will kindly hear me out then. Assume that their affidavit is their opposition. Is their case, I shall demolish their case on their affidavit.
Let's see if Mr. Dev comes on the next day. 21st I've kept that no further adjournment.
He will come and say one thing: plaint is not there. Plaint does not require.
Anyway, that also will be considered.
Obliged.
আচ্ছা আর আছে
Your Lordship, I am for the plaintiff. I am being led by Mr. Siddharth Mitra, senior advocate.
Yes.
Lordship,
Today is the date for your reply.
the judgments they have cited. No, no. Well, at 2:30, my Lordship, kindly excuse me. I have a division bench, broken bench fixed, my Lord. I will start. I will start just now. Lordship, here, my Lord, kindly notes by their case. One of the points urged with law is that there can be no partial rejection of claim. Some of the defendants, because Lordship may recall, this is for partition of the estate of Arun Bhutoria. Late Arun Bhutoria, whose heirs in intestacy entitled to his estate are four individuals. The plaintiff number 1, widow. The defendant number 35, mother. Defendant number 36 and 37, 2 sons. To that extent, the suit is maintainable for partition. And there can be no partial rejection of the claim. So, in other words, if I file a partition suit against my brothers and sisters, to that if I add ITC and Reliance and the chief minister of a state, they can't come and say strike me off, because the suit will be always maintainable against defendant numbers 1 to 3. So that the chief minister of Manipur and the defense secretary can be implicated in that suit. Lordship may recall, this is the নিচে আছে দেখছিলাম প্লেনটা, ওটা আমার প্লেন নাকি? ওইটা আমার প্লেন, ওইটা ওইটা ওইটা
Prayers in the plain pillar, composite prayer for declaration and partition.
That's what I said. So I will file a partition between the 4 sons and daughters, to which now Lordship kindly sees that the suit is for the joint estate. That Lordship will find at paragraph 1. And all material, Arun Bhutoria, husband of the plaintiff, was a Hindu. Paragraph 1, page 14. So after a lengthy cause title, the first paragraph is paragraph 14. Sudeep, তোমার লেখা প্লেনটা?
না না, তুমি তো অন্তত 10 বার পড়েছো। Only thing, we have all read this plan probably 20 times. Lordship need not look into the plane.
Okay, that's the whole point. Yes, Miss Dev is very right.
So there was amendment also.
Yes, don't look at the plane. This is his case. Please don't look at the plane. That's the only weakness in the case.
Without looking into the plane, suit is maintainable.
Yes, without looking at the plane. Yeah, that's the whole. I agree with you. I agree with you. Without looking at the plane, suit is maintainable. Now, Lordship, look at.
Reject,
My lord, I am appearing for
whatever it is. I have to confine myself within the plane.
Oh, so don't say look at
no
the plane.
fictitious things.
Don't look at the plane. Please don't say that.
My lord, I am appearing virtually for the plaintiff, my lord.
First time. And maybe 22nd time tomorrow. Because Lordship has said 2 days. If you can't conclude today, tomorrow. I hope tomorrow it will be
Tomorrow is a very auspicious day.
very good day, Dada. আসতেই হবে শনিবার।
But the resolution passed already.
আমি দুজনে আসছি।
আমি নালে
আসতেই হবে তোমার। বলেছেন এই মামলা নেবেন। আসতেই হবে।
আচ্ছা। ঠিক আছে, Lordship, this is a suit for the HUF of Arun Kumar Bhutoria. Now Lordship kindly sees the defendant numbers 1, 2. Not heirs in intestacy. What else? None of these companies were descendants of Arun Bhutoria. But you kindly note this, paragraph 48 to 40D. Page
Paragraph.
Page 33, capital A. So this is all about the partition of the estate of Arun Bhutoria. 48 to 40D.
33A and 33B.
Page 33A.
Page
33, capital A.
Yes, 33 capital A.
Paragraph 40, capital A.
Yes, paragraph
Under
40.
the aforesaid circumstances, it can be evident that the assets and properties.
So this is the amended relief.
Yes.
Yes.
Belong to the late Bhutoria. So this is Arun Bhutoria. And after his death, the said assets and properties had devolved upon the plaintiff and defendant 35 to 37. So the heirs so the joint co-owners are the plaintiff and defendant numbers 35 to 37. So the other defendants are feeling very upset. Why have you implicated me in your partition suit? And Lordship kindly sees who are the defendants. And why has the defendant number 1 been implemented? Because he was an employee of Arun Bhutoria. So, if I file a partition suit and if the estate comprises of 40 properties, the properties are not implemented as parties. It is the co-owners, it is who are the parties to the partition suit. And admittedly, defendant numbers 1 to 35 are not the co-owners. No. It is the Schedule E assets. Schedule E assets. I defend number 1 can't be an asset of Arun Bhutoria.
So 1 to 35 are not
party.
Are not co-sharers of the
that is their plain
suit
case.
property.
Yes. And the
so 48 does not seek any relief against defendant number 1 to 34.
Relief is claimed. Relief kindly come. Relief has been claimed.
No, where? So far 40A is concerned. Okay, 40B.
The plaintiff said that some of the assets were in the name of Arun Bhutoria, including shares which are standing in his name in several of the companies which were owned by him. However, some of the properties and shares which have been described in Schedule E were standing in the defendant numbers 1, 2, and 38. And they are holding the same as trustee for the benefit of the heirs of late Arun Bhutoria. To that, my lord, I had shown, Lordship may recall, sections 5 and 6 of the Trusts Act, creation of trust for movables has to be only following that procedure by registered instrument and by transfer by the settler. I will add upon a judgment also. So if I say that a part of the estate is standing in the name of ITC and standing in the name of Mr. some GD Birla, that does not become, and their properties are they're holding as trustees. Next is the defendant 1, 2, and 38 were at all material times standing in a fiduciary relationship capacity by reason of the relationship of confidence enjoyed by the plaintiff 1, 2, and 38 insofar as late Arun Bhutoria was concerned. The properties which are in the name of 1, 2, and 38 were all impressed with constructive trust. Lordship has noted section 5 and 6 of the Trust Act. The plaintiffs say that several of the properties are standing in the names of defendant number 3 to 34, but not as trustees. Shares of and in the said defendant number 34 were almost to the entirety held by Arun Bhutoria. Shareholders list করে পাবো shareholders list now kindly sees almost will become evident from page 51b. Who were the shareholders? Page 51 capital B. So that is the list of shareholders of the company.
Yes.
The first company, AK Computec, Arun Bhutoria held 100 shares out of 10,000 shares, 9,900 somebody else. So the 100 shares, of course, will be subject matter of partition. Next one, AK Foundation, 100 shares out of 2 lakh shares. Then number 3, Ashray, 5,000 shares out of 8 lakh shares. Sorry, 8.5 lakh shares. And thereafter, from the next page onwards, it is 0. Page 51C. Oikyaton 0. Akla Builders, yes. $7,000 out of say 2.5 lakh, but almost then alag 100 out of 10,000. Then so many companies. So almost entire. Firstly, that is no concept is almost entirely owned by the company. Even if the company held, even if the individual Arun Bhutoria held all the shares of the company, but the company's assets are separate. Company's assets can never be the assets of the individual. It is the shares which are the control. So all the shares will be partitioned. Company cannot be a so for example, let's take ITC. ITC must be having 10 lakh shareholders or maybe 1 crore shareholders. Each time there's a demise of shareholders and it goes to his heirs in the partition suit. ITC
properties cannot be partitioned.
Yes. So all the shares of these companies, yes, can of course be partitioned. But for that, the company need not be implemented. And here the insignificant shareholder, but let's take it as what he has said is correct. Almost 100% shareholder. Then 40C, page 33, capital A. The plaintiff states that several of the properties are standing in the names of the defendant numbers 3 to 34. The shares of and in the said defendant is almost entirely held. Arun Bhutoria, by your cross-holding, the particulars of shareholding of 3 to 34 will appear from a schedule. They are showed. The aforesaid cross-holding of shares is evidence from the fact that the 34 were in control of late Arun Bhutoria and the persons who are holding shares of such companies in trust and for the benefit of Lundbutori and after his death for his heirs. Several immovable properties standing in the name of defendant number 334 have all been given in Schedule E to the plaintiff. Incorporated in view of the 40D, in view of the aforesaid, the plaintiff has claimed rights to the extent of her 1/4 share in the said properties. In any event and in the alternative, the plaintiff is entitled to claim 1/4 right in respect of the equity shares of and in the said defendant 34 particular A2. So, my lord, there is no question of partial rejection of claims here. Here, this is a case where, whether you call it Order 7, Rule 11, or Order 1, Rule 10, you strike off the entities who are not the co-sharers. In a suit by partition, all the co-sharers are parties. This is the fundamentals we have all grown up. All the co-owners have to be implemented. And in a partition suit of somebody's estate, others, in fact, if somebody else had to intervene, they are not allowed to intervene. Because this is a suit between the co-sharers. This is simple. Now I'll come to the judgments which they have cited. I have a 2:30 p.m. fixed matter, my lord. If you also keep it on Monday, I can come and finish it on Monday.
You give your written notes. I'm keeping it on Wednesday.
Wednesday,
Summarized and all written notes.
And
all the parties.
Lordship, then Wednesday week, Lordship, can you make it because this is
Wednesday week.
Tomorrow, because
Tomorrow, yes, if Mr. Mitro can come.
I am not coming. I am not free at all. I am not coming, and I don't believe in Saturday.
I am ready.
And I don't believe in working on Saturday.
Milord, I am appearing virtually for the plaintiff.
I have grown up to come.
No, but I have heard Mr. Senior Mitro saying that in a particular Saturday he argued till 3 p.m. in a particular matter, some 10, 15 years ago, some 20 years ago. Yes, one matter. Just on the previous year also.
Maybe especially
yes, previous year also, Senior Mitro appeared in a particular matter.
Previous year.
Yes, in a division bench.
He's more youthful than me, man.
And he said his previous experience that it's similarly he appeared in other matters also.
I can't compare to him, my lord. I have never tried. I don't try. I have nowhere.
No, my lord, he did not compare himself with me.
Anyway, you do one thing. Either Tuesday, Wednesday, you come with your written notes, conclude.
I said, Lordship, keep it on Friday.
See, because I could have kept it on next Friday, but I may not sit on next Friday. That is why I want to keep it.
Because I can come and argue and finish my argument, no doubt. But my notes will take a little.
Simultaneously you do, because you are giving reply. It's
yes, I will finish it.
No question of beginning the argument.
No.
You have argued.
He is beginning to re-argue the whole matter afresh.
On the basis of your notes, you summarize.
Instead of Wednesday, a little 7 days time, or Monday week, or whichever day, give us 7 days to prepare the note. Coming here, coming and finishing my argument, no problem. Lordship, 7 days, are your notes ready?
Your notes ready? On the same day, conclusion as well as notes.
May I say one thing?
Take some time to give the notes.
I know, my other side is very.
I will not segregate. Your argument and notes all on the
same. Not together.
Yes, no question of segregating.
Lordship is only not next Friday or
next Friday.
Only one day.
I may not sit. That is why I am not keeping it on next Friday.
So Lordship.
So either this Wednesday, Thursday, as you think fit.
But any day next week, Milord, finish it off, Milord. Lordship said after Mr. Mitro concludes, Milord, Lordship will give us 5-10 minutes time.
Gone on for a very long time.
To show the note and explain what we have said in the note.
Yeah, I can do it.
Any
Thursday,
day next
second
week,
half is possible. Only note it will be.
Because you have to file your written notes, no arguments.
Yes, argued. Only Mr.
Mitro. Without hearing, I will not be having the privilege of. You see, almost everything is over. In reply, no new point can be asked. Only with points of law. Mr. Mitro has argued today also. Some points are left. So I am making it written notes and conclusion, everything.
Then Friday week. Lordship will not here next Friday week.
Then you see another thing. At the end of third weekend of this bench will not sit due to circuit also.
Next Friday week, 14th. 14th, my lord, is
Mr. Mitro is trying to speak.
14th.
Is there virtually?
14th, if it suits Mr. Mitro. If Mr. Mitro, it suits.
You see, All are to
My lord will just see one
all
thing,
have
my
to
lord.
submit the written notes. Only
Please,
you have
Mother,
to
can-
submit written notes and arguments.
I shall.
Submit the written note and
Note-
conclude the.
Yes,
Kindly
sir.
conclude the hearing, my lord.
Mr.
Kindly conclude the hearing, my lord. My honest request is to conclude the hearing, my lord. My lord, your lordship will look at the plaint and see whether it is frivolous plaint. And if it is not frivolous, my lord, the matter can be decided in this the trial. All these issues.
Getting the order.
Not, it is barred under law, on one law, Trust Act, whether it is barred under the NCLT, the matter has to go to NCLT. All these can be decided in order 14 rule 2.
On the next day, you come ready with your notes and whatever you submit.
Briefly, I'll argue.
Briefly argue whatever, because you see, after all, you argue tomorrow, day after tomorrow, all of you have to submit the written notes.
Lordship, whenever Lordship keeps it, notes, 15, 20 minutes, I shall finish my argument.
Yes, record an order. Learned advocates
have
for
my
the
sign.
parties are present. Heard Mr. Mitro has.
Abhrojit Mitro for the applicant.
Okay, Mr.
Abhrojit Mitro
has given reply with regard to the application GA
11.
Yes, just a minute. GA 11 of 2025.
Yes, ma'am.
As the arguments were heard at length and all the parties have completed the submissions.
No, my lord, there I have a small thing to say, my lord. On the last day, my lord, I wanted to show your lordship an order.
You see, whatever you want to do, you cover it in your written notes.
Lord, there are certain things, my lord, which have been argued, my lord, after the argument was made on our behalf. So obviously we have to deal it.
You covered it, you see.
I will cover it in my written notes.
Yes,
Certainly I will-
otherwise no use of again resuming these arguments.
Certainly not. Only on new facts what have been said, just two orders. Lordships on the last day said that I will give you 5 minutes time, because after all, the some of the defendants initially did not appear and has taken some new points. I said, very well. Once the
See,
argument...
if you want some time, then all will ask for
No,
some
no.
time.
Then Lordship can give me today 5 minutes time. I have
No,
no
see-
issue. Because after all, my lord, in a partition suit, my lord, I can be transposed and I can espouse the cause of the plaintiff also. Position is interchangeable.
Anyway, whatever it is, after
I can do
Mr.
it
Mitro,
today.
do it.
I can do it today.
No, do it on
5
14th.
minutes.
Because as well as I
Then
shall.
it would be easier for Mr.
And you
Mitro
clarify
to
it
give a
in your,
composite reply.
and you clarify it in your written notes
If
also.
some new order or judgment is being
No,
stated,
no
then
new
I have
order,
to,
no new
I need an
judgment,
advance.
Only
Request
clarification.
Lordship to see one order, my lord. May I
No
kindly request your lordship to see one order?
Only clarification.
Nothing else.
What is the
Only
clarification? If that can be indicated, I'll deal with it in my reply.
Anyway, let Mr. Mitro complete.
My lord, may I just entreat your lordship to see one order, my lord? I'm grateful your lordship allowed me to appear virtually, my lord. Only one order, page 25 of my affidavit, of the plaintiff's affidavit in opposition.
Show my lord an order. If
Yes, what is that order?
My lord, the order is 27th April by Justice Somen Sen.
Yes.
Allowing
Regarding
amendment.
Yes, I've gone through that. You have submitted, I've gone through that.
But that's the order pursuant to which the plaint was amended.
আচ্ছা পড়ুন তো কি আছে?
No, that was the order allowing the amendment, my lord. That was the order by Justice Somen Sen allowing
What
the
Mr.
amendment.
Mitro wants to
He
say
asked me to
that
set aside the order.
was converted.
And he has not filed it.
Partition.
That is your case.
Years.
You will also deal it within your written notes. Learned advocate
And for clarification, 5 minutes.
parties are present. As তারপরে কি লিখলাম Mr. Abhrojit Mitro.
1 বছর হয়ে গেছে? 1 বছর?
এইভাবে তো delay
In reply. তারপর as the learned advocates for the parties have completed their submission and Mr. Mitro has to conclude on the next day, let this matter appear on 14/8/2026 at 2 p.m. for conclusion
My lord,
of the arguments and filing written notes.
except 14th, can it be on 13th or 12th? Because my junior apprehends next day is 15th of August.
Yes.
So obviously there is a probability
Yes.
of not to pass any adverse order.
What adverse order will be passed on that day? Only the written notes you have to submit.
No, Mr. Mitro will obviously say that he will take some time. He will distinguish the judgments. He has said just now.
But kindly keeps it in 14th, we'll finish it. We have to finish it.
Then
Kindly keeps it on 14.
very well. Then Lordship.
Because if Mr. Mitra is unable to come, you just conclude.
He's making submissions, my lord.
It's a two-way, my lord.
No, 14, is there any difficulty on your side?
No, I have to. My lord, he
Very
said
well.
he
If
suggested
he does
14.
not have any difficulty, it's better.
Lordship will fix it at 2 p.m.
Yes, 2 p.m.
and kindly make it peremptory. Otherwise, this direction had been
Yes,
given
this-
thrice before.
This direction is peremptory.
Lordship. And let it appear at 2 p.m. so everybody
Yes,
can conveniently.
I've made it clear, conclusion of the arguments and written notes.
And peremptory.
Yes.
Kindly, my lord, add the otherwise.
Yes,
yeah.
I've been-
And 2 p.m. Lordship has fixed it. Grateful, my lord.
Yes.